So we'll begin.
We can start. Jay?
Yes, sir. Good afternoon, everyone. And on behalf of CEERA-NLSIU, a hearty welcome to our esteemed panelists and all the participants who have joined for this workshop on the Mediation Act 2023. The workshop is being conducted by us in collaboration with the Department of Justice, Ministry of Law and Justice, Government of India, in pursuance of a pan-India legal literacy project that we are implementing. Today, we have a stellar set of panelists who shall give an overview of the Mediation Act and mediation in general, followed by its advantages, the nitty-gritties associated with the procedural aspect, the significance of mediation, and also seeing the success of mediation not only in the Indian context, but also the South African experience. In line with the above, before we begin, what distinguishes a society's progress is not the absence of conflicts, but the manner in which it navigates and resolves them. In this context, mediation emerges as a beacon of hope, offering a pathway to resolution that is grounded in dialogue, empathy, and mutual understanding. And on this note, I would like to request Professor Sairam Bhatt, Professor of Law and Center Coordinator, CEERA, National Law School of India, Bangalore, to set the agenda and provide his remarks on the Mediation Act 2023. Sir, please.
Thank you, Jay Badrukam Mohanta, for commencing this very interesting workshop. We would call it a workshop to learn about the Mediation Act and the process of mediation. As Jay did rightly say, this workshop is being organized under the Department of Justice project on legal literacy and legal awareness. And we think Mediation Act is a very important intervention in developing a very robust alternate dispute resolution mechanism in India. Let me first put on record my sincere appreciation to all our speakers who have accepted our invitation and who have readily and willingly, agreed to share their experience and expertise on this topic. We have Srimati H.R. Radha. She is a judicial officer and the director of Bangalore Mediation Center. She will be speaking in the second session. So she will be giving us the first-hand experience of how mediation is working at the Bangalore Center. And being the director, I'm sure she has much to contribute in this workshop. We have Jishnu, who will also be giving us the aspects of the aspects of institutional and online mediation, because today I think the use of technology is going to be there to resolve conflicts and disputes. So the aspect of how we can use online mediation and what processes and how institutional support can be got, I think Jishnu will highlight them. Then we have Professor Jose Verghese. Professor Jose Verghese has had a very illustrious career as a lawyer, advocate in the Supreme Court of India. As an academician, he has been the Vice Chancellor of Hidayatullah National Law University as well. Currently, he is the legal advisor of the Institute of Social and Economic Change, ISAC, in Bangalore. And at least for more than 2-3 decades, I know him as a very successful mediator. So as a person who has mediated a lot of disputes, his experience is something that he will be sharing in this workshop. Finally, we have a very good friend of ours who is currently a judge of the High Court of South Africa, an Indian who, 3 generations back, they migrated to South Africa. He was a teacher, he was a professor at Port Elizabeth in the Nelson Mandela University. And from there on, he became a judicial officer. Now he is a senior judge in the High Court of South Africa. He also will be sharing his experience on the success of mediation in South Africa. So I would like to thank everyone for being with us today, all the resource persons. So thank you so much for being here. The first session, friends, will be something that me and Vikas will set the kind of basic overview of the Mediation Act and what this new law contains. and then the experts will probably come in. Yeah. Then probably our experts will definitely step in and give their insights on this particular topic. Uh, Let me just tell you that in India, the history of mediation is very, very important. And the foundations of the same you can actually find in various aspects in our society. You know, when there was a dispute, say in a village, we had the panchayat members, usually who would actually try and resolve this kind of a dispute. Friends, the point of mediation, as different from conciliation or arbitration, is that here you are trying to resolve the dispute. You are trying to bridge the difference between the disputing parties. And it's important in our society that we have people who not only judge the parties and judge the dispute, but who actually attempt to resolve the dispute amicably to the benefit of both the parties. And I think mediators, to be honest, to me, if I look at the history of mediation in India, who would mediate? Elders in the society would mediate. Prominent individuals who had a great influence on the parties would mediate. People, we have a great mediation kind of a center with religious and spiritual leaders leading mediation. Mediation usually is successful because what happens with mediators are, I think, more than anything, they are counselors. You know, they try to heal the difference. And hence, the approach in mediation, friends, is entirely different from any other form of dispute resolution. And that's why I think mediation requires trained mediators. It is not, those who are able to be judging the dispute and the parties where mediation should come in. So I think mediation is a very, very important and a critical component in our legal system. And this act is actually strengthening the mediation process. And I think it has a great future ahead to it. And I think to a larger extent, the way this act is now going to be implemented will make the sea change of difference between what can be on paper and how we can realize it on ground. So, Vikas, over to you now.
Thank you, sir. Thank you, sir. Friends, hi. So, friends, moving next, as Sarah said, that mediation is a form of AR. It is different from the arbitration. It is different from local. In what happens in mediation is there is a neutral third party who tries to resolve the dispute. Okay, there are two parties who are fighting. There are two parties who have a dispute, and the mediator, a neutral third person, tries to resolve the dispute. Friends, please note Section 3H of the Mediation Act 2023 defines mediation as a process whereby parties attempt to reach a settlement. Friends, please note the role of the mediator is to help, is to guide the parties, but it is the parties themselves who resolve their dispute, who agrees to reach a settlement on that dispute. The mediator has no authority to impose his settlement on the parties. It is the parties who have to, agree. And friends, now as per the 2023 Act, mediation includes pre-litigation mediation as well. Before this Mediation Act, we had different forms of mediation. Now, there is this thing called pre-litigation mediation where even before a case is filed before the court, parties try to attempt to resolve their dispute with the help of a mediator. That is what we call as a pre-litigation mediation. Then, friends, we have something called online mediation that our next speakers will discuss. We also have, friends, community mediation. And friends, please note interestingly, the definition of the term mediation also includes conciliation. It's a very important thing. Conciliation was dealt by the Arbitration and Conciliation Act. Now, as per the 2023 Act, conciliation is included within the meaning of mediation. It's a very important definition, friends. Friends, if the mediation is successful, we have something called a mediated settlement agreement between the parties. Okay, so after the mediation, if it is successful, the parties enter into what we call as a settlement agreement or a MSA, mediated settlement agreement. However, friends, if the mediation is unsuccessful, there is what we call as a non-settlement report, NSR. Okay, so far, friends, in mediation, the role of mediator is very, very critical. And why it is critical? As Sir was saying, we require, friends, trained mediator who know their role well, who know their responsibilities well, who know how to conduct mediation, how to attempt to resolve a dispute. And friends, that kind of training and that kind of role requires a specialized communication, a specialized way of communicating, a specialized way of discussing, a way, uh, inclination to resolve the dispute between the parties. That is what is required from a mediator. Friends, as per the Act, mediator does not have the authority to impose a solution or judgment on the parties. He tries to resolve the dispute. He tries to, you know, create an environment where parties themselves can discuss and try to come to a mutually agreed upon solution. Friends, the role of the mediator is that he has to be a neutral person. He has to be objective. Friends, most importantly, he also has to protect and safeguard the confidentiality of the parties. Friends, confidentiality of the discussion of the mediation process is one of the critical component of mediation. Whatever information is shared during the mediation between the parties cannot be used in evidence. Also, friends, please note the mediator also cannot be asked to disclose the discussion that has happened during the mediation. So the confidentiality of the entire process is safeguarded, is given a sanctity. Friends, the mediator has to be non-adversarial. He cannot know. एक तो पहले parties where there is a heated discussion, they are fighting with one another. If the mediator also takes one side, or he becomes an adversarial in nature, then resolution of disputes becomes very, very hard to come by. Friends, lastly, the function of the mediator is to encourage self-determination by parties. As I said, it's the parties who settle their own dispute. The mediator only helps. He assists the parties, but is a party who have to determine by themselves, okay, this is a solution that is acceptable to me. That friend is the role of the mediator in a nutshell. But friends, this role is what we call as a textbook role. But we say as an ideal role. But friends, in practicality, as the upcoming speakers will say, things might happen in a different way. Okay, so please make note of that as well. Friends, as Sir has mentioned, why do we require mediation? Friends, we all know that the judicial backlog in our country is enormous. If you look at the statistics, crores of cases are still pending before the Supreme Court, High Courts, and a subordinate judiciary. So, in the light of that, to secure, to decrease the backlog, we require alternative modes of dispute resolution. We require alternate modes of conflict resolution, and hence mediation helps in that. Friends, it has been noted by several persons that mediation is a catalyst for genuine justice and societal transformation. Now, why do we say that it's a societal transformation? It's a genuine justice. Friends, the constitution of our country says, the preamble of the constitution, to promote unity and harmony or fraternity between the people. Friends, fraternity and unity develops when people talk to each other, one another. They communicate to one another. They, instead of fighting, they comes to a no. There is a discussion. There is a communication between them, and hence, friends, towards that end, mediation builds a kind of an environment where parties can discuss and the parties can communicate to one another in a freely. Friends, it also includes exchange of ideas between the parties. And friends, most importantly, satisfaction. When the dispute is resolved to your satisfaction, it is what we call as genuine justice. When you have no complaints or you have no regrets that, okay, this settlement is acceptable to me. You are satisfied in a sense. And hence, friends, mediation helps in that. Lastly, friends, our country also has a dream or ambition of becoming an international mediation center. So the Mediation Act 2023 is a step toward that direction. It takes steps that will help in India becoming an international mediation center. Now, friends, before I go to the Mediation Act 2023, I have few questions to discuss with you. So far, in your understanding of mediation, and before we go to the Mediation Act. My first question is, friends, do you need a lawyer to participate in mediation? Please use the chat box, friends. We can look into that. So someone says no, you don't require mediation. Yes, Sakshi saying yes, we require a lawyer to participate in the mediation. Hina is saying no, we don't require. Friends, we do not require a lawyer to participate in the mediation. Parties can themselves go before a mediator and settle their dispute. Means, however, friends, in practice, what happens is, जब भी आपके पास कोई केस होता है या फिर कोई dispute होता है, you go to your advocate. And hence, friends, it is the customary practice, or what we call as the general traditional practice, that lawyers do participate in the mediation process on behalf of the parties. Do lawyers have a role in mediation, friends? Yes, they have. They can advise the parties, what is right, what is wrong, what settlement they can accept and what settlement they can't accept. And friends, in practice, what also happens is advocate of one party can also guide or counsel the opposite parties as well. जब आप एक mediation में होते हो, whenever you are in a mediation, the one advocate can guide the other parties as well. It happens also. Can parties appear before the mediator throughout their representative? Friends, the answer is yes, they can. Parties, the lawyer can represent them before the mediator. But friends, here is the trick. The lawyer cannot make decisions on behalf of the parties. He can only represent them. He can only appear before them. He cannot sign on behalf of the parties. He cannot make any decision that leads to a settlement on behalf of the party. That decision to settle the dispute is solely with the parties. Their lawyers can only help them and assist them. Friends, if the mediation is unsuccessful, okay, we saw that if the mediation is unsuccessful, there has to be a non-settlement report. In that non-settlement report, can the mediator mention why the mediation has failed? Can the mediator mention in his report why the mediation has failed? Yes or no? Yes. Okay, Ray. He's saying yes. No, he cannot mention. Who else want to? Yes, he can mention. Okay. Friends, please note, as per the Mediation Act 2023 and as per the confidentiality provision, the sanctity that is given to confidentiality during the mediation, why the mediation has failed or what has caused the mediation to fail is not disclosed by the mediator. He cannot disclose. Why? Because that will lead to an biasness or that can lead to a prejudice before the court that this party or because of this reason the party has failed to come to a conclusion. So to safeguard that, the mediator is not required to mention the reason for failure of the dispute. Friends, this is a practical question I want to ask. If the mediation is successful, who drafts the mediated settlement agreement? Who drafts the settlement agreement? Or who can draft the settlement agreement? Is it the mediator or the party who proposes the settlement can draft, or the party which accepts the settlement can draft, or all of these person can draft? We all will see that the Mediation Act, there is a mediated settlement agreement. Question is, who drafts it? The Act does not provide that. Who drafts it? Friends, as per the rules and as per the guidelines before the Mediation Act 2023 and the scheme of the Mediation Act and the role that has been given to the mediator under the Act, it is the mediator who drafts the settlement agreement. He confirms and clarifies the terms and conditions of the settlement agreement to the parties. He has to clarify that, sir, आपने in terms पे रखा है. These are the final terms of your settlement agreement. It is the duty of the mediator. Okay. Friends, when the mediator is drafting a mediated settlement agreement, can he use the standard template? No, उसका जो hard copy होता है और उस पे पेन से ही लिख सकता है, like we fill a form or something. Can he use the printed proforma and use his own handwriting to draft the mediated settlement agreement? Name of the parties, yes. Party B, ये रहा. Case name, case number, and that's so forth. Or it has to be a typed or something called a completely new mediated agreement. Friends, as per the Delhi High Court guidelines, no, the mediator should not use printed proforma or forms to fill out the details and say that it is the mediated settlement agreement. Why, friends? Because what the Delhi High Court saw is that many mediators are doing this practice, and hence the drafted agreement is very poor in its quality. And hence the Delhi High Court had issued strict guidelines in this regard, that please do not use a printed proforma to draft your mediated settlement agreement. And this is a very significant question. In which language is the mediation settlement drafted? Or it should be drafted? Does it has to be in English only? Does the mediated settlement agreement has to be in English only? Or can it be a different language as well? Friends, there is no specific language in which the mediation settlement agreement has to be there. The Delhi High Court, again in this case, said, friend, look, it is a settlement between the parties, and hence the parties should know the terms and condition of the agreement. And when will they know? If the mediation agreement is drafted in a language that is understandable by the parties, that the language in which the parties are comfortable. Friends, the language the parties are able to read. So in that case, the agreement as a practice should be drafted in a language which the parties understand. It can be Hindi or then it can be any other official or local language as well, which the parties are comfortable in. Friends, this question is also very significant for all our advocates and who want to practice in the mediation. When the mediation settlement agreement is drafted, made, signed by the parties, and everything is done, do you require stamp paper or do you require stamp duty to be paid on that? The stamp duty is required for the mediation settlement agreement, or the mediation settlement agreement can be in a normal plain A4 sheet as well. Yes, no? No? Who is saying no? All of you are saying no. Stamp duty required, friends. Unfortunately, the Mediation Act 2023 is silent on this aspect, whether the stamp duty is required or not. But as a practice, what has been happening is, if it is a court referred mediation, if the mediation is referred by the court, then stamp duty is not required. The mediator drafts it, he authenticates it, and submits it to the court, and he supplies one copy to the parties as well. But friends, if it is a pre-litigation mediation, or if it is a voluntary mediation between the parties, the mediation has not been referred by the court. In that case, friends, the normal or what you call the general rule of stamp duty will be applicable, and as per the means what authorities we have, stamp duty is required for every agreement that is being drafted. Friends, does the mediation settlement agreement requires to be registered? Friends, no. As per the Act 2023, the mediation settlement agreement need not be registered. The process is voluntary. But as your lawyers will be specifying that it is a very good practice to get the settlement agreement registered. Are mediators bound by a professional code of conduct? Absolutely yes, friends. They are bound. Supreme Court rules are there. Their legal service authority rules are there. And also the mediation center code of conduct is there, to which the mediator has to be there too. Friends, this is a very important question, and this will explain why a lawyer presence is important in mediation. Can a mediated settlement agreement violate principles of Indian Contract Act? Or can it go beyond the principles of Indian Contract Act? Can it contradict the principles of Indian Contract Act? Friends, please note, under the Indian Contract Act, if an agreement does not meet the requirement of that act, that agreement will be declared as void agreement, or it can be a voidable agreement. Friends, please note the mediation settlement agreement is also an agreement. It has to abide by the principles of Indian Contract Act. If it does not, it will be a void agreement and it will be unenforceable. And herein, friends, the lawyer or the advocates can guide the parties with respect to what kind of agreement will be enforceable and what kind of an agreement will not be enforceable by the courts. In which language, friends? It is the local language, or it can be any language in which the mediation can be conducted. Friends, just to give you the basic outline of the Mediation Act 2023, because our no the next 2 hours of the workshop are designed on the Mediation Act itself. So I'm sure the next speakers will be discussing the specificities of this act. Friends, the objective of the act is to, one of the most important objective is, friends, to facilitate institutional mediation. The act is structure found and gives emphasis on institutional mediation. We want to promote institutional mediation. Friends, also, it gives in clear term how the mediated settlement agreement can be enforced. What is the enforcement mechanism? How, where the mediators can be registered. Friends, it also encourages community mediation. We will come to in a later part. And lastly, friends, it gives acceptance, especially after lockdown time, lockdown phase, the COVID-19 phase. The online platforms have gained wide acceptance. Hence, one of the aims of the Mediation Act 2023 is to give acceptance to mediation that are being conducted online. With that, friends, I will conclude here and will ask Jay to take the step forward.
Thank you, Vikas. We'll come back to your presentation after our speakers have intervened in the matter. Jay, it's over to you.
Thank you so much, sir. And thank you, Vikas, for your enlightening session that busted a lot of myths with regards to mediation and the Mediation Act 2023 and how mediation actually works out. And now I would request Srimati H.R. Radha, Additional City Civil Judge and Sessions Judge, and also the Director of the Karnataka Mediation Center, to express her views on the advantages and process of mediation experiences from Karnataka. Ma'am, over to you. Can you please, can you hear us properly? Radha ma'am, can you hear us?
Jay, we'll just take a minute. We are getting in touch with Radha ma'am.
Yes, sir.
Oh. Yeah.
Hi, ma'am. Can you hear us?
Yeah, yeah. Sorry, there was some network issue and yeah.
No problem, ma'am. I hope the network is better now.
But there is still some issue with my video. Uh,
Ma'am,
yeah,
I
we can
think
commence. Yeah, we can commence the session, I think.
yes. And whenever
Yes.
you have a stable network, you can turn on your video.
Please. Uh,
Sure, ma'am. Over to
Thank you
you.
for this opportunity. At the outset, I wish to state is we have heard our previous speaker who has given us a brief introduction of the Act 2023 and how the concepts of mediation have been given statutory recognition there and how settlement agreements are done. Uh, Mr. Professor Sairam Bhatt has requested me to speak on uh, process of mediation, advantages of mediation, and the experiences of Karnataka Mediation Center, which happens to be the first one to commence mediation in the country. Karnataka Mediation, erstwhile Bangalore Mediation Center, was the first center in the country which commenced mediation process in the year 2007. We are a court-annexed mediation center. Pending cases are referred by courts for resolution through the process of mediation, which is a facilitated conversation between the parties. This ADR mechanism is a free and informal procedure which helps the parties to dispute, to negotiate, and come to amicable settlement without recourse to complex judicial processes. Why I say it is an informal process is it's not like a regular court setup where you have a judge presiding over, you have two advocates espousing your cause, and all nitty-gritties of evidence act and rules procedure, everything has to be adhered to. It's an informal procedure where a neutral third party facilitates the conversation between the parties. It's different from other forms of dispute resolutions, alternate dispute resolutions, in the sense that the parties participate voluntarily and the mediator has no authority to make a decision for the parties, as in the case of judicial system, regular court system, where parties present their cases, lead evidence, argue the matter, and supplement all the judgments in support of their case and leave it to the hands of the judge who has to appreciate the evidence, facts, and then give a judgment. So here, there, the judge is the authority to make a decision for the parties, whereas in mediation, it is the parties who decide their case. As I said, mediator is not the decision maker. He is not the advocate for either side. Instead, the mediator ensures that both sides have an equal opportunity to express their needs and concerns, explore all relevant facts, issues, emotions, and relationships. It is the parties who generate the ideas towards a mutually acceptable solution. How the mediation goes on, it's all about the process now. Once the parties voluntarily approach, matter is referred by the court, parties approach the center, and if both the parties are present, mediator will be allocated to them, assigned to them. Then they go to mediation halls. We have about 17 halls in the mediation center in Bangalore. There is an opening statement where the mediator tells them about the whole process as to what goes on there, what is his role as a mediator, and he'll expect the parties to introduce themselves. That's how the parties become comfortable and they open up. Then there is a joint session where the parties meet together with the mediator and communicate directly with each other. As I said, mediator is only a neutral third party. He will not say when, suppose I am a party before appearing in the mediation session, I air my grievance or whatever it is. Mediator sitting there will not say, "Oh, is it so? Did this happen to you?" No such reactions will be given by the mediator. Mediator is a neutral party who will only listen to the parties, and then there is a private session where the mediator is met individually by each party. Confidential issues are discussed there, and possible solutions to meet the needs of the parties is also discussed. If the party in the private session wants the confidential issues not to be disclosed, even to the other side, that will not be disclosed. And then through this process, the party retains control over what's happening there and decides whether to settle the dispute or not to settle the disputes. It's a voluntary act. Again, both parties have the opportunity to discuss the issues, to understand each other's needs, concerns, and explore resolution. This settlement can be beyond the terms of formal remedies that can be obtained through litigation. Why I say is this: in a court of law, when a party goes, he has to plead his set of facts. He leads evidence only on those set of facts. Any evidence adduced without pleadings is not looked into by the court. You want certain remedy, you want the remedy to be molded. Courts have the power to mold the remedy, but if the set of facts pleaded does not permit it, that will not be granted. Whereas in mediation, that can take place. Parties discuss, oh, this is not the relief I want. They would, when they go to court, they'll think sky is the limit for them. I will get everything under the sun. This is my right, they'll think. But then when they go to mediation, when the negotiation takes place, when the talks are facilitated by the neutral third party, they'll realize, oh, this is what I expected, but this is the limitation. In this circumstance, I think this is what I am entitled to. They'll understand that, and such remedies can be obtained, which is not permissible through litigation. And mediation also helps identify areas of agreement, incorporate them in final resolution. Thus, the decision making power rests exclusively in the hand of the parties. Only if both parties appear and agree, a case will be assigned to a mediator. If a party chooses not to attend mediation, the case will be sent back to the court for further action. We were also discussing about pre-litigation mediation in the earlier session. Mediation Act 2023 provides for mediation of litigation before they come to court, that is pre-litigation stage. This has been recognized already in the Commercial Codes Act, where Section 12A mandates that all commercial disputes has to go through this process of pre-institution mediation unless an urgent interim relief is sought. By Mediation Act 2023, this has been made applicable to all cases. There is one exception, and all mediation centers across the country have been trying this pre-litigation mediation in matrimonial cases and cases arising out of matrimonial relationships by virtue of a judgment of the Honorable Supreme Court in Deepa versus Srinivas Rao. In mediation, the mediators engage in a meaningful discussion with each party to identify their interests, context of dispute, possible options of resolution, and other factors. During pre-litigation mediation also, each party is at liberty to consult a legal expert or a subject matter expert if they do not have one. And then the experience of Bangalore Mediation Center is that preparation is a must for effective mediation. Parties should should obtain all relevant information needed to discuss the case and to make settlement decisions. For example, it's a commercial dispute where some recovery is to be made for the supplies made and other things, financial data, supply data like invoices, ledger account statements, calculations, all should be kept ready. In other cases also, data relevant to the claim should be kept ready. That improves the effectiveness of mediation and unnecessary adjournments. Then parties need to reflect on and outline discussion points that are to be raised during mediation, while each party should have a clear understanding of its own view of the case. It's helpful to think from the other's perspective also and consider the options that will meet the ends of justice or the needs of both parties. Parties are given an opportunity to discuss issues, to reiterate what the process is, identify their priorities and concerns, clear up misunderstandings, find areas of agreement, ultimately incorporate the same into final resolution. There can be no settlement agreement unless both sides agree. In the previous session, there was a discussion as to whether there is a compulsion to register these mediated settlement agreements. Act 2023 speaks of registration under the Act, that is Legal Services Authorities Act. Now the situation is the settlement agreements are reached, agreement is reduced into writing, parties sign voluntarily. In a court annex mediation like ours, we refer the matter back to the court with the settlement agreement. It is open to the court to consider the terms of settlement. Only if the court thinks that the terms of settlement are legal, then it accepts it. If the agreement entered into between the parties creates a new right or amounts to relinquishing a party's right in an immovable property worth more than rupees 100. See, the provisions of the Registration Act apply to all such cases. A party who intends to derive some right on the immovable property involved in that matter needs to register the agreements to exercise those rights. Wherever there is relinquishment of right or transfer of some property in favor of the wife in lieu of alimony is concerned, so such things need to be registered if there is no formal registered sale deed evidencing that fact. Then settlement agreement, as I said, will be drafted and it is signed by the parties and then sent to court. If a party is not represented during the course of mediation, he or she may review the draft and agreement by taking the help of an advocate before signing the same. If the mediation results in resolution, signed mediation settlement agreement is accepted by the court, it becomes final and binding on the parties to the dispute, and the party disobeying the terms of settlement is bound to face or execution proceedings for enforcing that agreement. While each case is unique, at our center, more than two-thirds of the cases mediated result in settlement. I'll be giving you the figures shortly. If settlement is not reached, the case will proceed by the concerned court as if no mediation ever occurred. Again, anything discussed in the mediation session remains confidential and the mediators will have no further involvement with the case. This is about, and this is the process of mediation. Now coming to advantages of mediation. The parties are at liberty to withdraw from the process at any time. The process is informal and very flexible. and no formal rules of evidence, no witnesses are involved, confidential process, because the mediators do not disclose any information revealed during mediation. The sessions are not tape recorded or videographed or transcribed. At the end of mediation, if any made by the mediator will be destroyed. It will not be sent to the court. Nor can a mediator be called to give evidence in that case, which was discussed in the previous session already. It's a very quick and inexpensive remedy when parties want to get back to their business and put their lives back on track. Mediation is the best option to consider, in my opinion. The process will be completed within 60 plus 30 days after the case is assigned to the mediator, provided the parties make themselves available for the procedure within the time frame. The length of time depends on the complexity of the case and willingness of the parties to resolve the dispute. Mediation promotes party autonomy and party control is greater. When a judgment or a decision is thrust on the party by a third party, there is always a tendency to challenge it. So when you find out solution for your problem voluntarily, parties do not wish to go against that decision many a times, and there is no challenge to this. And in mediation, there is no determination of fault. The parties reach a mutually agreeable settlement. There is preservation of relationship. Mediated settlements address all parties' interests. This often preserves relationships which may not be possible in a win-lose decision-making process, that is adversarial system. Mediation can also make the termination of a relationship more bearable, more amicable, because they would have expressed all their negative emotions and would feel lighthearted when they end the relationship. So it is always a win-win situation for the parties involved in it. Um, Parties are generally more satisfied with the solutions they have created for themselves as opposed to the solutions that are imposed on them by a third party decision maker. Mediated agreements often help resolve procedural interpersonal issues which are not susceptible to legal determination. They can tailor their agreements to suit their needs and work out the fine part of implementation also. This process, finally, I can say, acts as foundation for future problem solving, because after a dispute is resolved through mediation, any further dispute arising between the same parties, they are more likely to utilize a cooperative forum of problem solving to resolve their differences than to pursue a regular adversarial process. Now, coming to the success story of our center, we have seen nearly 160 reunions in matrimonial disputes during 2023. The success rate is 68%. 1,10,536 cases have been received from the courts from 2007 till yesterday, out of which we have mediated 86,370 cases. 58,385 cases have been settled. 22,474 cases could not be mediated at all for various reasons, such as parties' failure to participate in the process, failure to appear at the center to undertake the exercise, and some of the cases were not fit for mediation, etc. We get reference of all kinds of cases, original suits relating to partition suits, appeals are arising from all decrees, regular first appeals, revision petitions from family courts pending in the High Court, miscellaneous first appeals in family court matters again. matrimonial cases, criminal miscellaneous cases under Section 125 CRPC and the Domestic Violence Act, criminal cases under 138 of Negotiable Instruments Act, appeals from conviction judgments in NI Act cases, commercial disputes of late are referred by the courts in Karnataka, including the High Court of Karnataka, and we also get references from the Honorable Supreme Court. During COVID-19 pandemic, when the whole world came to a standstill, Karnataka Mediation Center took the initiative of conducting virtual mediation sessions through platforms which can accommodate video and audio communications. And we continue to work in a hybrid mode now. This is all about the process and advantages of mediation. If anybody has any question, uh, I can answer the same. I'm very sorry that I'm trying but not able to. There is some hitch with the camera. We have had a new system installed a few days ago, and there is some problem with this. In the chat box, I see some question as to how one can become a mediator. There is a 40-hour training to be undergone by the person interested in becoming a mediator. Um the Karnataka Mediation Center rules prescribes a minimum period of 15 years of practice for becoming a mediator, or even for choosing one to be a mediator. Then 40 hours training is conducted, and then they'll have to successfully complete 20 co-mediations and 15 individual mediations for empanelment as a mediator of Karnataka Mediation Center. Recently, our board has resolved to open up this avenue to the students and other professionals also, uh, so that we'll have more number of mediators. Probably with this, we are doing away with the 15 years of practice. Mediation, when taken up in the right perspective, I think is the ultimate solution for everybody's needs, is what I feel. Uh, because this has been my experience. Though I took up the charge of director just 2 months ago, as a referral judge, I have seen this. I was in family court, I was in commercial court. This has been my experience. Thank you, one and all. I thank Professor Sairam Bhatt for giving me this opportunity, the National Law School of India and the Department of Justice. Thank you. Thank you all. Any questions? You are welcome, sir.
Thank you. Thank you so much.
With your permission,
Yes, ma'am.
I
You
will
can-
be leaving the session because I have to go on with my
Sure.
regular work. Thank you so much.
Thank you very much, ma'am. Thank you for the presentation. In the meantime, we did show the website of the Bangalore Mediation Center. Sorry, Karnataka Mediation Center.
Karnataka Mediation Center.
So,
I also wish to state one more thing, sir, that we have internship courses for law students, 21 days internship course. We also train them. Trainings are conducted. Some refresher courses are also conducted in the law schools, where we are invited for this on a regular basis. I think ADR mechanisms need to be taken seriously as a career option by the law students, I feel. Hope National Law School of India University promotes this part. Thank you so much. Yes.
absolutely, ma'am. Not only we will do that in the Bangalore Law School, we'll try and reach out to all other institutions across India to promote ADR and the concept of mediation. Thanks to the Department of Justice project, I think we'll try and use legal literacy and awareness project to actually enhance the ability of law students and lawyers to resolve disputes in an amicable manner. Thank you very much for your session, ma'am, and thank you very much for your time and sharing your expertise about the Mediation Center.
Thank you, ma'am. And now I would like to welcome Mr. Jishnu Beetle, who is the sales head of Sama. And Sama is a mediation services-oriented platform that was founded in 2015, which is now a full-fledged online dispute resolution platform. So Sir is here with us to share his experiences in mediation, and he will specifically be sharing his insights on institutional and online mediation under the Mediation Act 2023. Over to you, sir.
Yes, good afternoon, everyone. Thank you very much for the introduction. Very polite of you. I thank everyone on call for having invited me here to share my 2 cents on what the Mediation Act in the perspective of institutional mediation and online mediation looks like. Now, I firstly would like to highlight that I am actually caught between the devil and the deep blue sea when it comes to the Mediation Act 2023. The reason being, I see there were few fine tunes that could have really made the act come through and sing through its power and really propagate mediation, especially for budding lawyers like us. I am someone who's graduated in 2019 from law school, and since then I have embarked on the mediation journey, and I completely advocate it even as a lifestyle when it comes to handling normal real life conversations or disputes that you have. To take a few pages off the act itself, institutional mediation, the reason even Mr. Vikas, who spoke earlier, was mentioning that it is one of the highlights of the act, is specifically because it's not closed it to public entities. It is opened it to private institutions, service providers, organizations that have been doing this on a daily basis. And since the pandemic, since slightly before the pandemic, the wave of mediation actually, it had been going around. And in various acts, we have seen amendments come in. We have seen the CPC amended to have ADR activities, have scope for it. All of this has been catered to it. And now institutional mediation, the real advantage of it is where the backlog issue gets solved. Now we are looking at mediation, especially from an angle of wanting to reduce the backlog of what is happening in courts today in terms of appointment of the judges, or be it the amount of time spent on a single civil dispute. But this moment you open the doors for private organizations and public organizations and NGOs to really conduct the mediation sessions, you will see that the amount of experience that you learn and to refine the act, number one, to improve on the process, number two, and number three, to really resolve disputes effectively, amicably, so that it never reaches a court again. Now, that is the main intention behind the act. And this, by inference, actually leads to the fact that the number of cases that go to court will then significantly reduce. So here, multiple institutions are there in the country, both public and private, who conduct mediation sessions. I work for an organization named Sama. We at Sama also do online dispute resolution, and we do it specifically in mediation, conciliation, arbitration, where we are an institution recognized by the Ministry of Law and Justice. Now, given the new Mediation Act, there is a Mediation Council of India that is envisaged. Now, here is where I believe few of the exceptional strengths of the usage of institutional mediation in just skin and bones in the act really help. One is mediation as on date in India is not really formalized. It is formalized to an extent of a mediation committee report that is issued by a panel of experts instituted by the Supreme Court. There are various smaller rules and regulations, code of conduct, ethics that we have aspired and inspired from international and national jurisdictions, and we have put it into a playbook of sorts, and where mediation currently happens. But having said that, a formalized process of what training, what code of conduct, what ethics really need to be incorporated into this activity doesn't come through. And we as law students, you know that even in the law school level, we are not educated about mediation to the level we may be educated about an Arbitration and Conciliation Act. Now, starting from there, I believe just the usage of institutional mediation will really improve the literature that we all as law students and otherwise get to start consuming at a very young age. And then we understand the real values and the truth and the efficacy of the process of mediation. Now, this also gives scope for standardizing the trainings and having a forum of mediators. Now, a community development should always be the angle if we are looking at solving a problem at scale. Mediation is a problem that we are looking to solve over 4.7 lakh pendency of cases in courts. So if we are to effectively leverage it, we will need to have community development that happens. And the community development can only happen if we have a structured uh, system in place to really have that done. Now, here's again where I would probably highlight a small reservation of mine, in the sense the mediation council itself, which is given ample amount of ambit in terms of how the rules can be modified, what the procedures need to be what are the procedures that mediation service providers need to handle. All of this is given to the Mediation Council of India. Unfortunately, I believe that the stakeholders in the Mediation Council of India may not always have the abundance of resources or experiences to really improve and develop on that. It is not open to mediation advocates. It is not open to ODR, ADR institutions. These are the real relevant stakeholders who, as on date before the act has come into place, have really worked towards probably formalizing what mediation it is that we see today. So here, institutional mediation, I believe there is a small lacuna over there. But having said that, just the usage of it should really inspire us young budding lawyers to really get on board with institutions. Have a look and feel of the platform. Have a look and feel of what real life mediation looks like. Because I promise you, I myself went for one mediation session where I got the privilege of sitting in a matrimonial dispute. That was a court referred mediation, and that changed my entire experience and opinion of what and how effective mediation can be. Institutional mediation, again, as a country, as an economic country that is looking to boom, we are looking to make ease of doing business that index, our ranking in that index was many years back about 124, which shows very poor signs. And the largest contributor to it is the pendency of litigation, or the average timeline of litigation to be 4 to 5 years. Now, again, opening up the doors for private institutions really increases the number of mediators, increases the avenues available to parties to really resolve the disputes amicably. The institutes will also ensure that there is a maker checker of sorts. Right now, mediation, if I have a dispute with a third person, we can mutually agree upon and decide upon a fourth mediator and have that mediation conducted. But I, as an individual who's experiencing mediation for the first time, would not really know if the mediator has actually upheld all his roles and responsibilities to the highest quality. But having a service provider, having an institution that also takes care, scrutinizes, regularly intervenes into the process improvement and feedback of the mediation process itself, the quality of mediation that we'll start getting in the country. And this country has seen great mediations. We have great lawyers ourselves who even mediated disputes like the Ayodhya dispute, like interstate disputes. So we're looking not at a simple, small one-person dispute. We are even looking at such large scale where state governments are involved. There are real emotional, underlying problems involved, and those have been successfully mediated. So the success story of mediation is now, I believe, with anyone who's heard about mediation would really buy into the concept. Institutional mediation really helps you just sing through, and also the experience that courts can also learn from all the cases that have gone by through these institutions. I think that will also help improve, speed in the process of jurisprudence when the Mediation Act really comes into force. So I believe there are so many nuanced advantages of just having used the term institutional mediation, recognizing institutional mediation, and at the same time giving the act the tooth to really enforce the mediation settlement agreements. I believe the biggest lacuna earlier when mediation was conducted without a formalized act was its execution value. It was a paper agreement signed between three parties, which really, though it was mutually consented by parties, really did not see efficacies. Here again, institutions will have more resources, will be better placed to really support the execution process. Again, more execution, meaning the courts across various jurisdictions will start seeing institutional mediated awards. We'll start seeing how mediations are occurring in the country. And I believe that is the only way, as a community, as the process, all of it can be refined and fine-tuned to a level where we are also reaching international standards of mediation, even though we may be doing it in a very unorganized manner right now. So this is with regards to institutional mediation. When it comes to the online mediation component of it, I believe that is the true strength of the act. The reason I'm suggesting this is because it's not just a development that has come in with the pandemic. You can see the level of integration of online that has been used across the act. If you search online mediation in the act, just on the PDF, you'll get 3 searches. But at the same time, across various acts, the updated definition of mediation, which also includes online mediation, pre-litigation mediation, institutional mediation, that resonates across various acts. If you read the Mediation Act, it supersedes about 6 acts or replaces language in about 6 acts, including the Code of Civil Procedure, the Arbitration Conciliation Act, the MSME Act, all of them where there are scope for alternate dispute resolution mechanisms. The definition of mediation being replaced by the Mediation Act's definition really, again, revitalizes the scope for online mediation. We are reaching a day and age where everything is happening at our fingertips. So the real question is, why not our legal disputes, and especially informal legal processes that we're calling mediation to be, that really are party autonomous and party autonomy related? Why isn't that going to be taken online? Now, that is what this act really solves for. It really literally takes any common man going to a service provider or going through a court and X center who have internet capacities to really conduct online mediations. Mediation in the olden days, when there were brick and mortar run institutions where parties had to go to a specific location, the mediator would choose a location which is, neutral. It should not be favoring a party, one party or the other. And they would try to find environments, conference rooms also. They would prefer circular tables because that would make parties more at ease. These are all learnings from mediation that have been conducted in Western countries as well as in India. And these roundtable conferences tended to be slightly intimidating to parties. And in India, our use case is for the common man more than the proficient, the educated. And our common man really cannot grasp what a brick and mortar mediation would feel like. And the mediators or the service providers would have to go above and beyond to make them comfortable in a new environment. But now, with introduction of the online mediation, it becomes so simple that someone from their own device at home with just basic internet connectivity, or maybe not even that, maybe on a phone conference, can really participate in a dispute resolution process that will give him validity of a settlement which is equivalent to a court of law. Now, this is demystifying justice. Justice that is so complicated, lawyers, the legal jargon, the length and cost of proceedings, all of these myths that we collaboratively call our legal justice system is breaking down because of this additional usage of online mediation. This again, and I believe one of the strongest implementations of this is in the Legal Services Authorities Act. The mediation process or the Lok Adalat process that the Legal Service Authority Act has included online mediation. This shows that it is not just an initiative at a tier 1 city level. It is an initiative for the tier 2, tier 3, tier 4 cities where they are the real use case of a Lok Adalat scenario. Now, if a Lok Adalat can be envisaged to be taken online, Sama, my organization, has done this back in 2020 during the pandemic. We did it with various state legal services authority. We were the pioneers of taking Lok Adalat online and digitally transforming this particular activity. Now, that really gave us insight that people where they felt safer, they felt more comfortable to really sit and log in through a device rather than appear in the local district court office on a set date. And the footfall is madness. If you actually visit a district court who has which is part of a local on a Lok Adalat day, you will actually see the extent of human beings that appear in a courtroom, and the administrative operational difficulties, the plethora of it doesn't stop. So here, that's again where online mediation for the Legal Service Authorities Act, that replacement, really now gives access to any state government to also exercise the online right. So right now, if we are having 10,000 people turn up on a single day, even if you can trim it by 10 to 15% of people who are comfortable turning up online for resolving their disputes, that really can be leveraged. And the online mechanism can ensure that the parties, from the comforts of their home without any more discomfort, already the dispute is disconcerting, they have been able to move past that by just appearing online on a session. Now, online also in this day and age comes with a slight curveball. That is also something quite brilliantly captured in the act in terms of confidentiality. The non-recording of video conferences, the non-recording of audio conferencing, I believe that has always, the confidentiality has been a basic foundation of mediation. And our act is no different in that regard. It also, because it captures online capabilities of it has prescribed certain rules which need to be followed in terms of confidentiality of personal information, in terms of what information needs to be disclosed. If there is a platform that is being utilized, all the parties need to be educated on the platform, need to be regularly updated of the sessions, they need to be getting notifications. All of this is being covered in the particular act. Now, this again ensures that in IT infrastructure needs to be strong enough, supportive enough, so that the parties at any point don't face any breach of their personal information or dispute related information. Here again, what this just implies that institutions currently offering mediation as a service will need to do one better or maybe many better to ensure that all the rules complied with the act, all the procedural and rules required by the act is actually complied with. Again, when quality of institution improves, quality of mediation, happiness quotient of the parties resolving the dispute, all of it will compound in such an effect that again, future disputes will not reach courts. And more than just trimming down existing court cases, I believe the attitude of all young lawyers should be to ensure that more cases in the future of the same party doesn't get filed. And that is what online again provides for. Now, there are some interesting online aspects that are being touched upon. There was a uh, there was a PK Malhotra committee, if I'm not mistaken, which drafted some rules and recommendations in terms of what the mediation, when it was the mediation bill, there were these recommendations put forth on what the mediation council should look like, what the rules and regulation or the roles and respective remuneration should be. It also brought about few features and few pointers that mediation institutions need to follow. One, to receive certification as a recognized service provider, but two, to also ensure that those standards are always upheld. Now, again, this maker checker that at one level, the mediation service provider or the institute takes care and ensures that their mediators and their service and their ancillary support, administrative support staff really do a good job of taking care of the mediation process. But having said that, they are later on accountable to a Mediation Council of India. Now, this two-tier check will always ensure that institutions never take this process for a ride, because we have often seen that institutions are not really preferred because there is always a concept of they can be bought off, or there is not going to be a complete neutrality in the process. Again, when it comes to payment terms, the act again captures if there is nothing expressly agreed by the parties to the dispute, it will be borne mutually. The cost of proceedings will be borne mutually by the parties. Here again, this is another super advantage that we see. Institutions will also give you choice. Now, we as first-time litigants may not know too many mediators to recommend, saying that I will choose X and you can choose Y. And basis that, we can finally finalize an appointment of a mediator. But when you approach an institution who already has 50 mediators, you can go through their profiles, you can go through their strengths. Some people also have this exceptional discomfort in having legal conversation in any other language than their vernacular. And in the online mediation space, you will see that a mediator's role itself changes. The trust building exercise that can normally happen across a table when you're sitting in a brick and mortar environment is not the case in online mediation. Now, here is again a slight reservation of mine with the act that the online mediation, how the procedure needs to be conducted, recognize the recognition of online dispute resolution institutions. These are terminologies, references, usages that currently do not exist in the act, unfortunately. The online mediation and the institutional mediation are two separate entities, where the act is not seeing that there are already existing institutions pan-India working over 10,000s of cases a year, which actually have a hybrid version of both. Though the act then again provides for certain support systems, support mechanisms in the form of recognition of electronic signature. Now, when you're in a Lok Adalat environment, when you're in a mediation environment, when you're really struggle to get two parties, especially on a video call where they're sitting far away from each other, try to resolve a dispute, the next step is a mediation settlement agreement. Now, what are the requirements of a mediation settlement agreement? It is that it needs to be executed or signed by all the parties, including the mediator. In this regard, in an online space, you again hit a roadblock. Now, when you hit a roadblock, what do? You'll have to physically send across the first draft, one person will sign, there'll be edits made. The timeline of dispute resolution unnecessarily aggressed. Here, the Mediation Act really is looking for quick closure and resolution of disputes, and in the most effective manner. Now, enabling electronic signatures as per the IT Act is another super useful addition uh, into the Act's arsenal. Reason being, electronic execution is a 5-minute process. There is a digital key involved, the Aadhaar based signatures involved. So there is referencing, there is identification of personnel that happens, and there's a unique private key through which they're executing documents. So here again, just bringing in online, also coupling it with the fact that Section 15 of the Indian Evidence Act signatures are applicable. This just increases a scope that in many occasions, multi occasions, you can actually have online mediation conducted. The online mediation is not a straitjacket use case that only for commercial disputes it can happen. It can happen even for the smallest ticket disputes, say a 500, 800 purchase order that you may have with some an e-commerce organization. It can be that small. Nowadays, there are a lot of disputes also that don't get filed. They don't get filed because people do not want to go through the rigorous rigmarole of having to file cases, pay a lawyer, appear in multiple hearing dates of a court, all of that. But again, introduction of online mediation, one, will ensure that such frivolous cases also do not reach courts. Number two, it also ensures that parties with an actual dispute can resolve it real time with ease. And that is when the happiness quotient, the ease of doing business quotient, all of that will improve in a country, indirectly booming the economy. And most of the legislations that we're looking at, which are pro ADR, which are not pro litigation, they're all in the direction to ensure that litigation or legal disputes become easier. Now, lastly, just to quickly also give you maybe a small gist of why, as young lawyers, institutional mediation matters, or institutional mediation can support your career trajectory. I will tell you that institutions that are handling real life cases have multiple opportunities where you can join them and work as a caseworker, where you're a third party administrative support staff personnel, and you can really experience what a mediation is like. So, for anyone in the room who currently has not seen a real life mediation, you could probably reach out to one of the service providers, try and get yourself an opportunity there, and be a real life case manager where you are part of a dispute resolution journey. That journey will actually show you and teach you the efficacy of mediation in the country. Number two, this is another advantage of the institutional mediation. Budding lawyers can get opportunities to see disputes grow into the profession, and you need not always stick to the straitjacket law firm karte, litigation karte, judge bante. There are these three general law school thought processes that go into any law student's head. But now there is actually a commercially viable model where there are many businesses using online platforms. They're leveraging technology and they're leveraging ADR solutions like mediation. And now with the Mediation Act, it's being extensively used to try and resolve disputes. And this will give you an insight of how you can probably progress in your career. Some institutions like ourselves, we also have an in-house course that you can do on online dispute resolution. This will again hone your skill in handling a dispute on the online platform, teach you the tenets of confidentiality, how there are no recordings, how real life sessions happen, and the works. It is also commercially rewarding. It is not somewhere where if you join as a junior in litigation, there is always an aspiration that it'll take you 5 to 7 years to really set up your practice. Now, right now, our country has almost reached the space where we can single-handedly, as a sole profession, handle ADR, ODR as a line of employment, and mediation has special truth there. And if there are any proponents of mediation, if you really enjoy or believe, you're curious to see how dispute resolution works in an institution, online, offline, please feel free to reach out after this. We would be more than happy to speak to you and try and accommodate and see how we can take things forward. But having said that, the Mediation Act really is a breath of fresh air. It was a need of the hour in terms of formalizing the act, and it also gave scope for many organizations to resolve their disputes far more smoothly and efficiently. Yes, thank you very much for your patience and in listening.
Thank you, sir. There is one question for you in the Q&A box. If you could, I'll read it out for you. The question is especially with regards to confidentiality and if your organization uses any software to maintain the confidentiality of a mediation proceeding.
Yeah, so there are multiple ways you can ensure the confidentiality of the proceedings. One is to ensure there are no video recordings. So at least at our institute organization, what we do is we tend not to use third-party video conferencing applications like a Zoom, like a WebEx, whatever it is, because the scope of access for any third party there is slightly larger. We have an in-house video conferencing platform. So there, recording and such restrictions are put in place to ensure that third party users cannot log in. There are multi-factor authentications to log into our platform. You will have to use your Google account or some single sign-on accounts to really log on to the platform. So there are few security practices in place. We have also certified ourselves with ISO certifications to ensure that there is no data breach or there is no confidentiality issue. Any data that is stored on our platform is also completely encrypted. So at a later date, it is not like a third party can again go into the case, read the facts of the dispute and understand what the dispute resolution journey look like. So there are many mechanisms in place. There are also IT regulations in place that is made reference to in the Malhotra recommendation report. And there also they're saying that it needs to be in consonance with the IT Act. So to best possible extent, whatever is possible, the highest standards of confidentiality are maintained. And then again, there is always private caucusing as an option, breakout rooms as an option. All of that is an option also to ensure that inter-party confidentiality is also maintained in a process of mediation. So all of that is taken care of in that manner.
Thank you, sir. I think that is the only question that we had. Thank you for the session and your insights on online mediation. With this, we move on to our next speaker, Professor Dr. Jose Burgess, an advocate before the Supreme Court of India, and who has a significant experience in mediation. With this, I hand over the session to Sir and request him to share his insights on the significance of mediation. Sir, please.
Welcome to a workshop at the National Law School, sir. Sir, you'll have to kindly unmute yourself before you commence to speak.
Oh, it was. Yeah, it was not unmuted. One second. I got two screens.
We can hear you, sir.
Okay.
Welcome, sir. Over to you.
Now, okay, thank you. The
Sir, you are muted, sir. If you would please unmute yourself once again.
okay. Though the topic given to me is the significance of mediation, the new act is a small baby just born 4 months ago. So what has been talked and discussed, the experience, etc., or without an act. So I would like to bring about a little bit background of it in detail. So I have passed on my paper, so that can be circulated to you are free to circulate to the participants. Now, by way of introduction, I must say the Mediation Act 2023 was long due. We did not have statutory mediation at all. It has now come by 15th September 2023 only. Till then, what were happening, I will describe a little bit. We did not have any specific and detailed statutory stipulations till now. Now, present one has we had what you call a conciliation, negotiation, etc., etc. But now the entire conciliation has been replaced There is an Act of 1996 amended twice, but now it has been totally replaced by this new Act. So no more conciliation. There are a lot of case law saying, the difference between conciliation and mediation. Now you need not worry about it. Now everything is mediation. Now, this Act of 2023 was preceded by a bill at 2021, a mediation bill, and there was a nationwide consultation. On behalf of ASSOCHAM, I myself had participated in the consultation, but unfortunately, the suggestions we had given at that time to the bill was not considered. Probably it lost in the crowd. Mediation was in the soul of our country. It is in practice in our country from time immemorial. Angada of Ramayana and Sri Krishna of Mahabharata, they were the first mediators. So we never had any litigation. The litigation is it's imported from British. All throughout we had mediation only. Or in Kautilya, of which I am supposed to be an expert, my book is about to come. In his Arthashastra had given mediation is pristine important. He named it Shama. Shama means, peace. Which means peace to be the first four methods mean upayas, to be resorted while dealing with the difficulties that a Vijigishu, a conqueror, may face while making efforts to establish a Chakravarti Kshetra. That was our, what the Indians wanted to build in the Bharatvarsha, which is supposed to be the vast expanse between the Himalayas and the seas. But the four upayas, Sama, Nyaya, Danda, Bheda, only the first one was supposed to be used. And he had 28 kinds of sandhis. Sandhi mean what we call agreements for peace. 28 kinds before you resort to any force. Now, all methods of litigation and negotiation, conciliation, arbitration, they were all brought into by British. First, into the Civil Procedure Code in 1908. Then, even then, there was a Section 89 which was amended. Even then, mediation was not part of it. No, when Section 89 was amended, then mediation was part of it. Till then, this was in 1999. That means from 1908 to 1999, there was no mediation in the statute book. Now, by Section 59 of the Mediation Act, that Section 89 has been totally removed. We don't have Section 89 at all. It has been by a schedule, it has been removed. I will tell you what happened in between. The constitutional validity of the amendments of the Code of Civil Procedure Code in the amendment 1999 and 2002, that is on Section 89, and this was that was challenged. The constitutional validity was challenged and it was rejected in a case called Salem Advocate Bar Association, Tamil Nadu versus Union of India in the year 2003. But that court said that, you must operationalize Section 89. So there was a judge called, was a friend of mine, Justice, what's his name? Jagannath Rao. He was our visitor in the National Law University, Raipur. So he, after retirement, he went into the Law Commission, and there he made elaborate changes in the Arbitration Act. And this job of bringing a report, operationalized Section 89, was given to him. And it is he who brought out a report in 3 parts. And one of them, the second part, contained the Civil Procedure Mediation Rules of 2003. These rules had 28 rules. And these were the rules which were till now practiced until this new act came. And these 28 rules were approved by the second Salem Advocates Bar Association case in 2005. Before that, we did not have, before this act, these 28 rules were in practice. All the cases that has been going on was under those rules. Immediately after those rules, I have given in my paper all the 28 rules, just for information. Now, immediately after, the High Court of Delhi for the first time established in the year 2006. Madam who just came about the mediation center said it is here in Karnataka in 2007. Of course, that was by Justice Joseph, who was a judge in the Delhi High Court first, then came here as a Chief Justice, then went to Supreme Court. It was Joseph who started here in 2007, but Justice A.P. Shah of Delhi High Court started in 2006 in Delhi itself. And I was associated with it because my classmates, many of them were the judges in the Delhi High Court, like Justice Sikri. They said, sir, you must also come. You have experience in this. And I was associated with that center right from the beginning. Now, my experience in mediation starts with, mostly matrimonial matters, and there was custody matters. Matrimonial matters was not that difficult, but the custodial matters were very complicated. Many of them used to reach the Supreme Court because of the confidentiality. Because in custodial matter, there is a counselor who represents the child. And whatever they bring in the report, it was not supposed to be made public. And also, whatever the parties say, that is the confidentiality which the Act say. But whatever the child say is not the part of the Act. Even it was not part of the rules either. Now, I remember in those days, following those 28 rules, we used to have first a common meeting and set agenda for the mediation. Then there, that is the place where we have to give the maximum time for the parties to express whatever they want. Because a lot of heat generated, because of the dispute. So that has to be undone. That is the stage we allow them to, just keep on speaking, shouting at each other for the maximum possible. Then slowly the mediator will talk to one after the other in turn. Then thereafter, they come together and start negotiating. So this I will explain a little later. See what all things are involved in that actual conduct of mediation, which has been now to a great extent modified under the new Act of 2023, while they were done under those 28 rules. Now, the mediation gets full statutory recognition as arbitration. Now, Arbitration and Conciliation Act of 1996, amended several times, is now confined only to arbitration. That conciliation part has been removed and totally given to these 2023 Mediation Act. Now they have added pre-litigation mediation, as the director was telling. Then there is online mediation. Then community mediation. That is an interesting part. Community mediation means, suppose a riot take place. It can be mediated, but it is very rare they settle the dispute. I'll tell you why. Then there is the conciliation, and conciliation treated as mediation. This is under the new Act, Section 55, 56, and 61. Then international mediation is now permitted, but only to the commercial dispute and no other dispute, international mediation. Now I'll tell you what is this process of mediation, what is the soul of mediation. If one may ask what exactly mediation is, I must say it's a process in which the neutral third party assists the participant in resolving their dispute through a series of joint and separate sessions. This is what Madam also said. That is the substance in brief. But it's actually an art. A mediator has to be a real actor or actress. The focus is on the problem, and the parties get enough opportunity to express their grievances. You have to allow them to speak, especially in the beginning joint session. They shout at each other. You must allow them. It involves certain amount of bargaining. That bargaining will start after their heat is come out. Both in law and in circumstance, bargaining in order to arrive at an amicable solution. The mediator assists the parties to go to the root of the problem, to find a solution, and for that purpose, he may throw light on the rights, obligation, and liabilities. This is not done in litigation. In litigation, the moment you go to the court, they will first ask, what is your right? Here also the obligation, when I say my right, there is a corresponding obligation on the other side, which is not, the litigation is not the area. And liabilities. That is the weakness of each party has. All these three has to be highlighted by the mediator. It is not a simple joke how to do it, both in law and in the circumstance of the case. Many of the rights, obligation, it may be customary, all that has to come in. Now, both in law and the circumstance of the case, and also the hidden dangers involved in if the parties remain adamant with the dispute without cooperating for a solution. What could be the danger? Recently, I did a mediation here. It was, the one lady alleging sexual harassment of the other, both the employees. So I told the lady in private, look, it is you who will be suffering if the matter goes to court. Because it is like, whether the leaf falls on the thorn or the thorn falls on the leaf, it is the ladies who will suffer. And that stigma will remain throughout your life. Please reconsider of insisting it. I will try to get the best solution for you in the present circumstances. And she agreed. Then I talked to the other side. So therefore, this is very important. The hidden dangers involved in if the parties remain adamant with the dispute without cooperating for a solution. How to do that? It's a big job for a mediator. And it depends upon the circumstances. That's what I'm saying. A good mediator is also a good actor. One of the parties may have to surrender certain perceived rights to maintain and restore healthy relationship between the parties. This is important. One of the purpose of mediation is to restore back the healthy relations they maintained before the dispute arose. How to do that? It is not very easy. The relation which they had, you must remind them sometimes, the good old time they spent together. That's why I'm saying you have to use a lot of imagination. So the maintain and restore healthy relationship between the parties. One may have to sometimes say sorry. You must insist you say sorry to the other. Maybe to the other if the circumstances warrant. The effort of the mediator is to give expression to the willingness of the party to restore the pre-existed amicable relationship based on human values, which alone brings about true peace and prosperity in life. So how to put them back into the situation where they were happy at one time? It's not an easy job. So no book will tell you. So it is during the training. The mediators have to be told this thing, how to get this done. You have to have a lot of training courses because it's not easy. So what is the qualification for appointment of a mediator? Successful 10-20 mediations, he said. How will you do 10-20 mediations? That is why I am offering myself as a mediator to get experience. That itself is, I remember when I went to Delhi in the beginning as a lawyer, I went to a lawyer. Says, shall I join you as a junior lawyer? He looked at my CV and said, no, I don't want to take you because I was too experienced. So he found danger. So the opposite also is true. A mediator cannot be, over trained. And they are also very dangerous. But in a case of mediation, once the ultimate aim is to find a solution for the two warring parties, then everything is good, both in war and peace. Now, mediation presupposes certain amount of equality of the disputing parties. This is very important. Mediator has to consider both the parties are equal. No mediator has been told this. If they are not equal, then there is no give and take. There is no bargaining. So your job is, mediator's job is to present that you two are equal. That is very, very important. Otherwise, if I surrender something, the other will take advantage of it. So you have to be very careful. So you presume that or try to see that the disputing parties are equal. I've given an example here. Even Gandhiji took initiative to maintain the welfare of the textile labor as a part of his struggle for independence, and he was willing to play the role of a mediator to resolve the conflict between the workers and the management of Ahmedabad textile industry in the year 1920, and succeeded by resorting to, how did he give equal power to the workers? By resorting to collective bargaining. Yeah, because unless there is collective bargaining for the workers, they will not be equal to the strength of the management. And he visualized it. And he succeeded by doing this. Perhaps collective bargaining in the entire labor workers process started with this kind of involvement of big personalities, and succeeded by resorting to collective bargaining in favor of the workers. It was impossible to achieve that if the workers were left alone to deal with the issues in their individual capacity. If each worker, it is very easy to make him, convince. But collective bargaining in labor matters, that what made both the parties, workers and the management, equal. So in mediation, that is the strength. A mediator can show that both the parties are equal in his mind. And don't tell the parties. You have to presume the whole work has to start with that in view. Then ask for give and take. The next question is, what are the disputes that can be referred? Now, it is more textual. See, earlier, the 28 clauses, the rules, do not have this much detail. But the new act has given details. What are those disputes that can be referred to mediation? You have to stop, when the time is up. Okay, 10 minutes left. Okay. The dispute that cannot be referred by the Mediation Act. The scheme of the Act is that all disputes which have arisen or which may arise between the parties, unless declared as not fit for mediation, is subject matter. Now, it can be referred to mediation, and there shall be a mediation agreement in writing. All that is as said. In case of international mediation, as I told you, it is only commercial dispute. And what are commercial dispute? It is given in the Commercial Courts Act of 2015. There are 22 categories. So only those commercial disputes can be mediated under because as a statutory provision now that can be used as a international for the what you call international mediation and not other, because in the international ADR also it is commercial, but it is a very loose term used there. But in mediation now they have come very clearly those 22 categories which are defined as commercial dispute in the Commercial Courts Act of 2015, and nothing more. Like James Hartley Chase said, nothing less, not a penny less, not a penny more. Now, the disputes that are declared not fit for mediation, there is a long list given in the present Act. One should go through it, and there are almost 11 of them. One is the dispute expressly prohibited, the dispute which are claims against minors and DTs. Now that reminds me, little deviation. You remember the yesterday's big function in Ayodhya? There it is the DT is the party. The DT has been given the land, and but the court tried to send the matter for mediation. Now they have come out very clearly. At that time, this provision was not there. They would not have sent it for mediation. Obviously, it failed for many reasons. So against the minors and DTs, the dispute against person of intellectual disabilities under Rights of Disabilities Act, there are persons defined. Against them, there is no mediation because they are not equal party. Then those with a mental illness, that equality will not apply, statutorily declared. They cannot be. Those with unsound mind, no equality. Then against the government, no mediation against the government. So you have to be very, very careful and go through these 11 categories. Again, the same thing. Where is the government? Where is the citizen? Where is equality? Then for a declaration of right in rem. In rem mean those public at large which are not specified, because it is impossible to enforce. So those right in rem is not possible to be mediated. Then criminal offences. Madam was saying the criminal cases are coming for mediation, but now the Act has made it very clear. Criminal offences cannot be part of the mediation except those contained as a compoundable offences. See, that's why this new Act has given a lot of clarity on many of the areas which was not available in the previous 28 rules. Then, complaints and proceeding initiated any statutory or relating to registration, discipline, misconduct of any practitioner, like lawyer. You cannot dispute with a lawyer. You cannot bring it by way of mediation. But they did. In one of the cases, they did. And I told them the professional dispute should not have come for mediation. But court referred. And we told the court this could not have been. But now the act has come very clearly. The professional misconduct, like medicine, medical practitioners, it is under the commerce, what we call the dispute redressal commission deals with it. So, because therefore it is not to be consumer dispute court deals with it. The architect, chartered accountant, or any other profession. Now, the 10th category is rights against a third party. That is not also, you cannot mediate. And there are 8 other categories where each act is mentioned. I will say the one is where jurisdiction is given under a particular act, like a green tribunal. Now, an environmental dispute, which is covered under the Green Tribunal Act, cannot be subjected to community mediation. Now, like that, direct and indirect tax, no mediation. Those proceedings that are covered under the Competition Act, Telecom Delegatory Act, Electricity Act, Petroleum, Natural Gas, Securities and Exchange, and Land Acquisition Act. There are a lot of cases in the land dispute they are doing it. Land dispute you may, but not Land Acquisition Act. Now, a few remarks I would like to make, if there is time, only 4 minutes left. The first is, this act has given, after the settlement agreement is made, you can challenge it under certain provisions. But if the matter is negotiated and settled in, then how do you challenge it? And earlier, the 28th clause did not include the process of challenge. And it is not correct, because even in civil law, a compromise decree cannot be challenged. So, settlement agreement is like a compromise decree. So, how will you challenge it? That provision is little superfluous. They must think. And during the consultation on the bill, I had suggested this. You cannot challenge a compromise decree. So too, a settlement that is arrived amicably between 2 parties. Don't give. Now the problem has arisen if there is any fraud, any bias, etc., etc. That in that consultation I had suggested, if those are that came out after the settlement agreement is made, then you can. Because it was not coming to the knowledge of the parties during the process when they agreed. But if they came to know after the act is done, then a challenge of that agreement on the ground of fraud or a bias, etc., is possible. Suppose the mediator is found to be a very close friend of one of the parties, which was not disclosed or which was not known. And obviously, he will certainly try to favor one party. So if the parties to the settlement agreement come to know, it happened in one of my cases where this judge, he was a retired judge, he was deciding a mediation matter, very high stake mediation. But his earlier when he was a lawyer, his office was next to this party's office. They were neighbors, which we came to know only afterwards. We made a lot of research and came to know. Then we challenged it. So that's a totally different question. Now, next question is, 1 more minute left. That is registration. Now there is registration given. But it is very unfortunate. If the challenge procedure is avoided, registration should have been automatic and sorry.
I think he has concluded. Sir, you can continue.
Yeah, it should have, but the Act gives 180 plus 180 days time for registration, which is wrong. Because and the third one, the last one is that for the execution, the Act say that the Civil Procedure Code will apply. That is also wrong. Application of Civil Procedure Code for enforcement of the settlement agreement means bringing in Order 21 of CPC, which where only tendency to prolong execution under CPC. But that they have come back into the Act through the back door. These 3 points needs to be considered. Legislature has to consider these are the 3 weaknesses. Otherwise, this Act, 2023 Act is one of the best, and it gives statutory recognition to the mediation process, and it has done away with the conciliation, which was brought in by the Britishers into India through Civil Procedure Code. Thank you very much.
Thank you very much, sir. Loads of experience from your side. I think it definitely adds a lot of understanding of the mediation process that has evolved, helping the courts and the court system. Professor Jose Borges has that rich experience coming not only as a very senior advocate in the Supreme Court, but also as a member of tribunal, as a teacher, and now as a legal advisor to many entities. So thank you very much, sir, for that intervention and for the suggestions that you have made on the observations of the Mediation Act 2023. We'll move on to our next speaker. Again, a very good friend of mine from South Africa, Dr. Avinash Goenji. Dr. Avinash has been a visiting faculty at the National Law School. He was a teacher, and now he is a judge in the High Court of South Africa. It's a great privilege for me to welcome him. He has been very kind enough to accept our invitation to join in between the court hours. This is a lunch break for him, but his commitment to the National Law School and to the activities of CEERA, I think he has obliged to share his experience on mediation. So Avinash, welcome, and it's over to you.
Thanks very much, Sairam. It's good to see you, and thank you to the Center, CEERA, and also to the National Law School for the kind invitation. Certainly, you can't be accused of forgetting your old friends. And although I'm half across the world, so it's just gone 1 p.m. Over here. Of course, we have fond memories of long periods of time spent in Bangalore and at the National Law School, periods in residence as a visiting professor, and so times have moved on. Sairam, your hair's still black. Mine, you can see, has disappeared, and what's left is grey. But enough of that. It's good to see all of you, and I was excited to see that India has moved towards a mediation act of last year. I've just heard Professor Verghese part of his comments. I've only managed to have a brief look at that legislation, but there are some interesting things that I've picked up upon that I'll try to reflect upon, just to make the talk context specific. I really want to deal with four aspects. In overview, I want to start with the labor law mediation dispensation in South Africa. I always say the South African legal landscape for foreign audiences is notable in at least 2 respects. One is, of course, the Constitution of the Republic of South Africa, which borrowed from all the best instruments around the world because it came into existence so late, and really is critically acknowledged globally as being one of the foremost constitutional documents. And the other is the Commission for Conciliation, Mediation and Arbitration, which I think is one of the most successful mediation bodies established globally. So I want to reflect briefly upon that. I then want to talk about some other legislation which has included mediation as an option in the South African landscape. We don't have an overarching mediation act as India has moved towards, so we can talk about that. We have an arbitration act, not a mediation act. I then want to talk about the uniform rules of the High Court, which opens the door to mediation by agreement in civil proceedings, which I think resonates most closely with what I see in the Indian Mediation Act. And then I want to talk about the practical way in which that works, because the Act has limitations. Sorry, my apologies. The uniform rules of court and the manner in which they're implemented has limitations. So I want to talk a bit in closing about how practically one in South Africa navigates the uniform rules in order to make mediation more real for parties engaged in legislation. But let's start then with the first one. So post-democracy, you'll recall historically that South Africa was under an apartheid regime. It was the fall of the Berlin Wall in 1989 that started a process with the sort of reduced apparent threat of communism and the like, an unbanning of political parties, the release of Nelson Mandela, and a move towards a interim constitution in 1993 and a democratic constitution in 1996. And of course, that in fact is the correct starting point, because Section 34 of the Constitution provides that everyone has the right to have disputes resolved either in a court of law or in an appropriate tribunal. And the legislature at the time saw that as an invitation, and arguably the most successful tribunal that has been established in democratic South Africa has been the Commission for Conciliation, Mediation and Arbitration. So the Labour Relations Act of 1995 included a chapter that established the Commission for Conciliation, Mediation and Arbitration. I'm just going to refer to that as the CCMA. That is the statutory body established by labour legislation in South Africa post-constitution. It constitutes a tribunal that is an alternative to court. It's run by a governing body. It's an independent juristic person. Of course, we're dealing in the labor context, so the governing body comprises, it's a tripartite structure. It includes 3 members from, let's say, representing government interests, 3 representing the interests of employers, and 3 representing the interests of employees. It's a labor tribunal. But just to give you an idea, when I say this is one of the most successful mediation bodies globally, in the first 10 years, and I'm rusty on the recent statistics, but in the first 10 years, the CCMA had close to 1 million cases referred to it. These are all employment disputes, from large-scale industrial disputes involving Anglo-American or De Beers, some of the mining companies and the like, to what one would call a Madam and Eve type scenario, domestic worker challenging an unfair treatment on the part of their employer. Of those, approximately 70% were settled by the CCMA, and they did so within a period of 30 days. So that represents really the high water mark of successful mediation. In a nutshell, how did it work? Well, first you have to understand that it was compulsory. In the employment context, one could not bypass a trip to the CCMA and approach the courts directly and say, well, no, we're a big company, we don't have time to go to the CCMA. Of course, the CCMA appoints commissioners. So I've just mentioned the governing structure, the governing body with a tripartite nature, but there are hundreds of commissioners appointed across the country. I served as a part senior commissioner while I was at the university for a period of close to a decade. So I was fortunate to have experience of the inner workings of the system. They were both full-time commissioners, people who only did this for a living, and people like myself who were at that stage based at the university and would give 1 day a week and go to the CCMA and then be allocated cases. And to give you a sense of a general misconduct type of dispute. So let's assume an employee in any organization or in a residential situation was charged with theft and they were dismissed, they would have within 30 dismissal, they would be able to go to their nearest CCMA office. They would be assisted by administrative staff. They would fill out a referral of dispute to say, well, we believe that we have been dismissed unfairly. I'm not going to get into the substantive aspects of employment law. Suffice to say that in order for a dismissal to be fair, it would need to be fair both substantively. In other words, there would need to be a fair reason for the dismissal, as well as procedurally. There needed to be a fair procedure followed prior to dismissing the person. And so the employee aggrieved would refer the matter within 30 days. Within 30 days thereafter, a commissioner would be appointed, notification would be sent to both parties to say that there will be a conciliation hearing on such and such a date at the offices of the CCMA. How that would work practically is that one of these commissioners, part-time or full-time, on the staff of the CCMA would literally, and that would be the role that I would fulfill, for example, would come there, would go into a waiting room, would say, well, can we have Mr. X and Miss Y, the employer and the employee, are you here, are you present? We go through to a meeting room, and then the rules would be laid down. All the standard attributes of classic mediation. There's no possibility of settling the dispute unless both parties agree to settlement. Anything that you say is off the record. It's completely without prejudice. You should feel free to speak freely. And then the commissioner had wide powers to hear both sides, move into side caucuses if need be, and use whatever strategies they could to try to get the parties to settle the dispute voluntarily. You couldn't bulldoze your way through to a settlement. Of course, you've heard these statistics were tracked, but one needed to operate ethically, and commissioners were trained. If that dispute remained unresolved, so typically 30 minutes to an hour would be the amount of time. If more time was needed, then more time would be given if there was a chance of settlement. In the event that a settlement could not be reached for one or other reason, the employer simply said, no, I know what we needed to do. We needed to give a hearing. We did that. We had a good reason. We've got evidence of misconduct. If that was the case, then simply a certificate would be issued, and that would simply say, no, the matter cannot be resolved, and the matter would then proceed through to arbitration. So a two-step process in most cases, and generally that worked very, very well. As I said, about 70% of the cases were settled within that 1 month period during that 30 minutes to 1 hour conciliation session. You couldn't force an employer to settle. If they said, no, we're not going to, a certificate would be issued, and the matter would then move forward to either compulsory arbitration, or if it was a large-scale retrenchment, to a different dispute resolution pathway. So that was the starting point. But let me move outside of labor. That's just to give you a snapshot of what really put mediation/conciliation in South Africa in the public eye. If I look at eviction law, the Prevention of Illegal Eviction from an Unlawful Occupation of Land Act, there's an example of other legislation which opens the door, interestingly in this case, to a municipality to be, in other words, a local authority, to be the trigger for referring a dispute to mediation. Now, what would be the thinking here? Well, typically with an eviction, if one thinks of homeless persons that have occupied land that belongs to another person, the landowner brings an urgent application in the High Court seeking to evict those people in order to have their property back, so maybe they can dispose of the property or generate income therefrom. How our eviction law is developed is that there's an obligation on municipalities or local authorities to try, where possible, to find alternative accommodation for people who are at risk of homelessness. And so factors to be considered, particularly the extended family, child-headed household, women, vulnerable persons. And as part of that, a municipality would need to file a report with the court in order to explain, well, either we have or we don't have alternative sites available. But that's really not the point for today's purposes. Of interest is that a municipality could, when asked to file such a report, act as a broker in terms of setting up a mediation process involving the landowner, the party seeking the eviction, and the person who may be at risk of homelessness, the people occupying the land. And the Act deals then with the mediation process. So that's just another example outside of the labor framework that I thought I'd share with you. There would be other examples of legislation containing aspects of mediation. I happen to have an eviction case in the last week and came across the mediation provision and thought, let me share that with you. And if need be, I see CEERA has shared a file or two, we'd be able to add both the Labour Relations Act so that you could see the constitution, the governance for those that may be interested of the CCMA, which I've already dealt with, and then the what's called PI, the Prevention of Illegal Eviction from an Unlawful Occupation of Land Act. So you could find, I think it's section 7 or 9 dealing with mediation. Let's move to the Uniform Rules of Court. So there was a lot of positive sentiment that, well, let's look at the success of the CCMA. This is a wonderful way, all the usual reasons for supporting mediation. They're meant to be more cost effective. They're meant to be less time consuming, that this could be a panacea for the backlogs in litigation that we experience in South Africa. You can imagine in all the divisions of the High Court, South Africa operates, you need to understand just briefly the structure. We have the High Court of South Africa, which is not to be equated with, for example, the Supreme Court of India or the United States. Our highest court is the Constitutional Court of South Africa. Just moving down, we have a Supreme Court of Appeal, which is one level down from that. And then we have the High Court of South Africa with different divisions in each of the provinces in the country. So there's, in a sense, one High Court. It's not the highest court, it's the High Court with 2 courts above it. So the rules that I'm referring to are the rules of the High Court of South Africa. They are uniform rules which apply to the High Court in all its divisions across the country. That's the rules I'm referring to, particularly Uniform Rule 41A. And then there are, let's say, local rules which each division. So I'm from the Eastern Cape. We have additional rules that apply. They're not relevant for today's purposes. So what the uniform rules sought to do is to say that in every action or application, so we are dealing in the civil realm. I'm not going to get into the criminal side of thing. They're really, yes, plea bargaining in terms of our Criminal Procedure Act, that is possible. Plea and sentence arrangements, I suppose one could stretch and say there's an aspect of, it's not really mediation, it's more settlement between the parties, so I'm not going to go there. But what Uniform Rule 41A does, it says that every time action is instituted in a South African, in the High Court of South Africa, it must be accompanied by a notice in terms of which the plaintiff or applicant indicates whether they are open to mediating the particular dispute. In other words, I'm instituting a summons, I'm suing you for 10 million rand or the equivalent, but together with that, I issue a notice that says this dispute is possibly one that could mediate. There is possibility of settlement, or alternatively, and this is the more common experience, no, we've sent a letter of demand, we've tried to be reasonable, no prospect of settlement, we're not inclined to mediate the dispute. The party then, that is the defendant or respondent, must of course now either plead or respond if it's an application by way of filing answering papers. In doing so, they need to give their indication of whether they are open to mediation. Now, this could have a costs implication down the line. If the plaintiff is unreasonable and says, no, this matter can't be mediated, the respondent says, but we are willing to mediate and do so. And it turns out ultimately the matter proceeds to litigation because you can't force parties to mediate. If the court feels that actually this was a matter that wasted the court's time, it should have been mediated, the fact that the respondent indicated that they were willing to mediate may result in an adverse costs order being ordered against the applicant. Bear in mind that at any time prior to a judgment, the parties can agree to refer the matter to mediation. So even if it doesn't start off on that basis, once the trial is actually started, then you need the judge's permission, but that's not going to be refused. And I'll come back to that when I deal with the practical aspects. How it works practically, and then again, CEERA, I suggest this would be a third document that we could share, is an extract of the Uniform Rules of court, particularly Uniform Rule 41A that details mediation in the High Court. It requires a joint signed minute. This is now in the case where both parties, absent court intervention, are eager to mediate the matter. So the matter seems to be litigious, but the parties have seen some common sense and they've agreed to mediate. They should sign a minute. They would file that with court. What that does practically is that it suspends all processes. So depending upon where the matter is, perhaps it's still at the pleading stage, it would suspend the due date for delivery of the next document for that period of 30 days. If, let's say, all the pleadings have closed, we're waiting for a court date or a trial date, and that's the point at which parties agree to mediate, it would suspend the matter being set down for trial for a period of 30 days. Of course, the parties are free to only refer some issues. It may be that the dispute is complicated. The bulk of the issues may need to be litigated in court, but there may be one or two issues that the parties are willing to mediate. They are free to do so. What is of interest and of relevance, certainly for me in my present role, is the power that the rule gives to a judge. And I say power in inverted commas, you'll hear it's not really a power. A judge may do is at any stage before judgment, direct, that's again seems like a strong word, direct parties to consider referral of a dispute to mediation. So it's really not that strong. In other words, the most that I could do in a high court action or application where the parties have not themselves gone to mediation or referred the matter to mediation, they haven't signed an agreement, is to say to them, as I've done on occasion, that this seems to me to be a matter which shouldn't end up in a judgment of this court, and one may motivate the reasons for that. So typically, family disputes, disputes involving relationships between the parties. I'm going to give you an example now of contested divorce proceedings where the parties were unrepresented. Various circumstances may trigger a judge exercising their power in terms of Uniform Rule 41A. The matter has been set down for trial. Of course, the judge does not want to convey the impression that the judge is reluctant to proceed with the trial. Remember, parties have the right to have the disputes that they have resolved before a court or an independent tribunal. So it needs to be in appropriate circumstances, but the rule gives the judge the power to try to convince the parties that perhaps we need to stand down for an hour or two. Why don't you try to either talk, but clearly you can't settle. But here's a matter where I think with an independent mediator being appointed, it could be that this matter could be settled quicker and cheaper than what would happen. We're at the door of court. We're about to embark upon a 1 week or 2 week or 3 week trial. That's going to be a win-lose scenario. Once the judge gives a judgment, and then one might be in the realm of possible appeals. But for various reasons, the judge may recommend that the parties consider referring the dispute to mediation. Let me jump in before I deal with the practical aspect to say immediately that I think one of the flaws with our present system, unlike what I see in your Mediation Act of 2023, is that there's no Mediation Council of South Africa in the sense of a national body established by legislation. The CCMA, you'll recall, is really only established in labor legislation. It operates in the labor realm. So we don't have a system of formal accreditation of mediators, a national list of mediators. So one of the immediate questions that arises if a judge manages to convince the parties that, yes, let's send this to mediation, who are they going to refer the matter to? In a sense, that's now going to be left to the parties to deal with. But so that's perhaps something that one needs to reflect upon. Let me give you a practical example, and let me say, as a disclaimer up front, that I think that in as much as the Uniform Rules of Court contains this rule, you can hear that it's extremely soft. The idea is that each matter, the parties apply their mind as to a possible mediated option. The reality is that in only a fraction of cases is mediation actually the avenue that is followed. In only a fraction of cases would judges exercise their power and recommend to the parties mediation, and only in a fraction of those cases would the parties perhaps accept that invitation. That's not to say that it can't happen successfully. Not so long ago, in the fourth term of last year, so in November or December, I had a divorcing couple appearing in person. Now, that doesn't happen often in the High Court because of the costs involved and the business of the matter. Normally, there's legal representation. In the case of criminal proceedings, there would be legal aid representation. Here, fortuitously, I think, as it turned out, lawyers from both sides had withdrawn on the eve of proceedings. And you know why that typically happens is because the parties have run out of funds. So they both had a major dispute. The husband was paying maintenance that he felt could not continue forever and was too high. The wife felt that the divorce needed to be brought to an end, and in fact, she was entitled to more. Classic impasse between divorcing parties, acrimonious now in the extreme. Papers now filed at the last minute by lay litigants without the assistance of legal representation. In short, an absolute mess of a court file for the presiding judge. So this was a great opportunity. So in the end, I end up spending about an hour with the parties, talking to them about Uniform Rule 41. There's the spirit behind mediation, and explaining to them that this was a case where the court felt it was in the interest of justice that the parties consider mediation. Remember, it cannot be imposed, even by the court. Fortunately, both parties were amenable to that. They'd reached the end of their tether, and they accepted the invitation to refer the dispute to mediation. Now, the next question is, as I've indicated, who is going to mediate the dispute? Now, fortunately, what has happened, I've said to you, it's not particularly regulated. There's no formal accreditation or training that is nationally recognized. There are various training programs offered by universities and private entities in the country that have mushroomed in the absence of a statutory framework for accreditation and training. Legal aid clinics. These are state-funded entities. They are frequently linked to universities. There might also be other legal advice officers outside of universities in the country. They have done quite well, particularly in this province where I have more knowledge of their qualifications, where they've equipped their staff and sent them to mediation training. So in this case, an obvious referral point for these parties that could no longer afford legal representation was to ask the director of the legal aid clinic closest to the parties if she would consider mediating the dispute. Now, how it works there is, with any legal aid provisioning in South Africa, there's a means test. In other words, at least one of the parties needed to fill out their assets, their income. They needed to convince that clinic that they were lacking sufficient means. In other words, they were worthy of legal aid. In this case, of course, the legal aid was not going to be to represent each of the parties. It was going to be legal aid in the form of the director agreeing to sit as the mediator and to embark upon a mediation process. So it would be then for that person to enter into an agreement with the parties, craft the rules of engagement. Might this matter come back to court? Yes, unfortunately it might. Has it come back to court? No, not yet. What does that indicate? I can't say for certain, but either the matter is still being mediated, alternatively, and hopefully the parties have been able to, with the assistance of the mediator, enter into an agreed settlement of all of their disputes. Hopefully, they've now managed to enter into a divorce agreement, including a settlement agreement. The bonds of marriage would have been terminated, and the mediator would have assisted them to enter into a comprehensive settlement agreement that would have sorted out all the issues which had brought them to court in the first place. It's gone 1:30 here on the dot, which I know would be then what is that, almost 5 o'clock, CEERA. So let me at this point pause and see if there are any aspects that aren't clear which you'd like me to expand upon. Thank you. Thank you for the opportunity.
Thank you, Avinash. It's a great opportunity for us to meet online on this platform. And I know for sure your work, not only on labor matters, but on matters in which you have acted yourself as a mediator and now as a full judge and a judicial officer in the South African judicial system. But Avinash, just to say that Professor Jose Vargas also has a great interest in labor law. He was a member of CAT, that is the Central Administrative Tribunal, which is the kind of a labor court in India for deciding matters of employment vis-a-vis central government. So he shares the same subject matter expertise and interest that you have as well. So it was great to have both Professor Jose Varghese and Avinash on the same platform.
Wonderful. Thank you.
Friends, before we move on, not to miss out on the opportunity and time that both Professor Jose Varghese and Avinash are here, if there are any questions that our participant want to post, may I request you to use the chat box, because we are in a webinar mode. I will not be allowing you to unmute. But if you have any questions for our speakers, please use the chat box, and I will probably moderate those questions to our experts. Quick questions?
So there is one question in the Q&A box, if you can see that.
This is a very broad question, and the question is, can we stop political influences in the judiciary? Maybe we should align it to mediation. Can mediation stay away from political influences? I think Avinash first and Professor Jose Varghese next.
Yes, I think it's I think one of the pillars of the South African framework is the strong independence of the judiciary. I know one wants to now link it to mediation, but I think there is a link in the sense that the legal fraternity and I'm okay. It is really steeped in this notion of the crucial importance of independence, of impartiality, the separation of powers, particularly at the High Court level, is such that although the issue, unfortunately, like in all jurisdictions, rears its head from time to time, it's not clothed with the same type of sentiment or controversy that I sense coming from the Indian situation. So in the mediation context, of course, it's less of an issue because frequently, and I believe it's the same in terms of your act, I think it excludes, for example, the high-level parliamentary structures. And likewise here, we're dealing with mediation frequently in the context of natural and juristic persons. So there's also not that much reason for political parties to be interfering in matters that are essentially, in most cases, private disputes, either between natural persons or juristic persons. Frequently, these matters are the high commercial matters. I didn't have a chance to talk about the Arbitration Act. It's not mediation per se, but just to say that the Arbitration Act has provided an alternative form of dispute resolution, not through mediation, but through independent arbitrators that effectively take the place of judges. So frequently you find retired judges of the Supreme Court of Appeal, for example, who've amassed tremendous experience, making very lucrative careers post their retirement from the judiciary in terms of arbitrating aspects in a particular niche area such as mining law. So I'm not sure political interference in the context of the mediation that we are talking about here is really a very, very serious issue in the South African context. Thank you.
Thank you, Avinash. Professor Jose Varghese, there are two questions that I can request.
My answer is threefold.
Right.
Number one, mediation works as a lis inter partes between two parties, and government cannot be a party because it is private law. When the government comes as a party, then it becomes public law. So mediation is not, that's why our new act has very clearly said, against the government, no mediation. Second, a mediator, if it is a government sponsored, he is going to be a government employee paid by him, by the government. how can a private party expect 100%, however conscientious that judge is? I had tried my best, but still people shout at me whenever they lose the cases. So it is impossible for a government. Now the third aspect is when you say politics, whether it is party politics or politics as far as the governance is concerned, party politics never. And as far as the government is concerned, sometimes, as he rightly said, it can be an arbitration and not a mediation. Thank you.
Right. There's two interesting questions here, and I'm addressing it to both of you. One is, what about mediation in a foreign country? Will it have a similar enforceability in the domestic jurisdiction? And what happens if one party does not obey the settlement?
To me,
Go ahead, sir. Go ahead, sir.
Our present act say how it can be enforced, because the present act is following the Arbitration Act of 96, because it all depends upon, number one, the act say that it will be treated as if it is a mediation whatever mediation takes place outside will be treated, if it is to be enforced here, as a mediation within the country. Now, second aspect is that there must be what you call, whether it is a mediation settlement agreement or an award, there must be an understanding between the countries, treaty between the countries for enforcement. If it is not there, it is not possible. Earlier, we used to have what you call the common law jurisdiction, and there were common writs applicable to common law jurisdiction. They used to do through that source and enforce decrees in all the common law countries. But now that has been done away with. I can tell you example, but it is very complicated. But otherwise, the enforcement is not difficult in India, provided the procedure followed in that country is not too obnoxious to the procedure which is prescribed under our Act. Thank you.
Yes, but perhaps just to add that this is it is complicated terrain and not something that I've had personal experience of. It's also then in the realm of private international law. So firstly, one would look at the contents of the agreement, the mediation agreement between the parties, and then, as Prof has indicated, the contents of any treaties in terms of the practical enforcement between the two countries in question.
Avinash, there is a specific question to you. This is regarding South Africa's strong protection to the right of shelter, and how can the eviction process, especially when there is a collective spirit of the evictees, can mediation be used in such process?
Yes, so I think that was the example that I tried to cite, that it is interesting that in our eviction legislation, or let me call it the legislation that was enacted to protect the rights, it's not only of the persons being evicted, to be honest. The title of the act is the Prevention of Illegal Eviction from and Unlawful Occupation of Land Act. So it seeks to strike a balance between the competing rights of landowners to the property that they own and the rights then of unlawful occupiers. That's the term used in the act. And as I suggested, what is of interest is that act includes a mediation clause. I'll make sure, CEERA, that I send you an extract of that, or the entire act, so that those that are interested can see. Again, it's a sort of nice to have inside the act. How often is it? I've said to you earlier that it's municipalities or that have to file a report on what alternative shelter would there be for parties at risk of homelessness. Our law is developed in that regard. A person claiming homelessness would need to set out a basis in their opposing affidavit when opposing the eviction and then the municipality has a duty to file a report. And then as part of that exercise, it would be open to a municipality to say, well, actually, this is a case that perhaps there are prospects of mediation. Practically speaking, how often would an eviction dispute be mediated? I would venture to say that at present, it's not something that is being mediated successfully very often, notwithstanding the inclusion of a mediation clause in the legislation. You see the clause, you will see. And perhaps then, while I have the floor, to draw then the difference between the inclusion of mediation in the labor legislation, which is compulsory and which led to those staggeringly successful mediation efforts, versus the manner in which it's been included both in the Uniform Rules of Court in respect of general litigation and in PI in respect of eviction. I would say it's hardly been used. I saw another question earlier about the differences. The one I just want to pick up upon between what I see in the Indian Act, and of course I'm not an expert on that, is the 30 days versus the 180 days. The 180-day period, I heard Professor Verghese just touch upon that, but that is an inordinate amount of time to permit for mediation, particularly in the context where courts are and the judiciary is frequently under attack for the slow pace of resolving disputes. 180 days, and I think I heard Prof say another 180 days to enforce. Well, if you contrast that with the 30-day time period in our labor dispute resolution process, you see, and I would say our labor context gives an illustration that it can be done a lot quicker than a time frame like that. Justice delayed is, of course, justice denied.
Yeah, pose it to both of you. This is a combination. The combination is like, is there a limitation for taking or challenging a mediation agreement, or would something like a res judicata apply once a mediation settlement has been done?
No.
Okay.
Because the rules of evidence as well as procedure is not applicable. It is the principles underlying that applicable. So it is left to the discretion of the mediator.
In the South African context, CEERA, what would frequently happen, like a divorce settlement agreement, which has been entered into inter partes or perhaps with the assistance of mediation, the parties would frequently approach the court, the High Court, to make it an order. Once that happens, in terms of our prescription legislation, it's now, in a sense, prescription is not going to be an issue, or the statute of limitations is not going to be applicable in respect of the enforcement, because you now have an order of court. And then there's a further difficulty, of course, in the event that a party fails to comply with an aspect of the settlement that is being made an order of court, there's a risk of contempt proceedings, because now there's non-compliance with a court order.
Thank you, gentlemen. Thank you for taking this, interaction and probably the learning of the law in the operational side and the practical side. I'm sure the participants have gained a lot from your insights. So thank you so much for extending your time to answer these questions. Thank you, Dr. Avinash. Thank you, Professor Joseph Verghese. Thanks a lot.
I must appreciate the whole workshop. I see 138 participants. It is a real good success.
So we had more. We had, I think, 170.
I
I think slowly, some of the practitioners had to leave. Maybe they were in the court or they had some other sessions. So of course they had to move out. So I now hand it. Yeah, Avinash.
Sorry, CEERA. Let me also just thank the Centre. I know time's out, but I encourage those attending to continue to draw comparisons with the South African context. Thabo Mbeki, when he was president just after Nelson Mandela, wrote an article that spoke about India and South Africa, and the article was entitled "The Ties That Bind," and the ties run deep. And there's good reason for that, both in terms of the colonial context, of course, but also then in terms of the post-constitutional dispensation. So for people interested in these areas, I think there's rich source for comparison. The Constitutional Court of South Africa has referred to the Supreme Court of India in some of its judgments, and likewise, particularly in the area of socioeconomic rights, the jurisprudence of our courts have been instructive. So thank you for, in a sense, honoring that relationship. It's been a great privilege to be here and to also share the platform with Professor Verghese, and good to see you and wish everybody well. Thank you.
Thank you, Avinash. Thank you so much. We will move on, friends, for one final leg where I'm inviting my colleague Vikas Gehlot. He has some last concluding, presentation to offer to you. So it's Vikas now. Vikas, it's over to you. We just conclude this session with an additional insights. Vikas.
And thanks to the holders, speakers also for sharing their thoughts and views on the Mediation Act 2023. Friends, during the course of this 2-hour-long workshop, we have discussed several parts of the Mediation Act 2023. I am going to deal with some more parts, to give some additional inputs on that. Friends, if you look at the Mediation Act 2023, it is applicable only to mediation that are conducted in India. First of all, we have to note that it is not applicable to the mediations that are conducted outside the country. So if a mediation outside the country is there and you have reached a settlement agreement, the enforceability of such settlement agreement is still not made a statutory mandate through the Mediation Act 2023. Okay. Secondly, friends, if you note, it mentions international mediation also. But for that to happen, that international mediation should also be conducted in India only. So if an international mediation is conducted in India, the settlement agreement of that mediation can be enforced through the Mediation Act 2023. Friends, importantly and very significantly also, in line with the Commercial Courts Act, friends, also note, in the Commercial Courts Act, commercial disputes in which government is a party are also subject matter of the commercial courts and the pre-institution litigation. Pre-litigation and mediation. Similarly here, commercial disputes where one party is a government party and such disputes are of commercial in nature, but they do not reach the threshold to become a commercial dispute under Commercial Courts Act, then such disputes also can be dealt by the Mediation Act 2023. Lastly, friends, the central government or the state government can extend the applicability of this act to more such disputes also. That is the flexibility, or what do we say, the power that has been given to the central and state governments. Friends, sir was discussing the disputes which are not a subject matter of mediation or which cannot be a subject matter of mediation as per the 2023 Act. Friends, my question is simple. Is this list too long? I think this list is too long. It can be cut short. Some of the disputes can be made as subject matter of mediation. What do you think, friends? Me and sir were having a discussion. No, about the recently, abhi kuch din pehle, the temple has been very in much discussion. Ram Mandir finally ban chuka hai, uska udghatan bhi ho chuka hai. And sir was saying that Ram Mandir mein bhi mediation hi hua hai. right? Ram Mandir dispute mein. Or if you read point number 2 of the first schedule, it says that the disputes of deity are not subject matter of mediation. Now I'm thinking, यार राम मंदिर में हो सकता है तो बाकियों में why can't there be a scope for mediation? These are some questions, friends, which I leave you with. And some of you have also asked whether a matrimonial dispute, which is of section 377 or section 376. Friends, please note, matrimonial dispute in order to be mediatable, it has to be with relation to a compoundable offense. If the offense is not compoundable in a mediation dispute, that dispute cannot be referred to mediation. And also, friends, the outcome of compoundable mediation disputes is not binding. The courts sit in the, they have to see whether the agreement that has come can be enforced or not, or should that be enforced or not. As a matter of course, they are not binding still. Friends, pre-litigation mediation has been dealt with. We all know it has been going to the Commercial Court Act. But the difference between the pre-litigation mediation under the Mediation Act 2023 and the pre-litigation mediation under the Commercial Court Act is very significant. The significance is, friends, that under the Commercial Courts Act, the pre-litigation mediation is mandatory. Before you file a suit in a commercial court, you have to mandatorily go to the pre-litigation mediation. Here, friends, under the Mediation Act, this is voluntary. You may go, you might not go. It is up to you. We might say, okay, यहाँ पे भी इसको mandatory कर देना चाहिए था, but that's a different thing. But as of now, pre-litigation mediation under the Mediation Act is not mandatory. You may go, you might not go. And also, friend, in pre-litigation mediation, there is no compulsion that आपको settlement agreement करना है. आपके प्री लिटिगेशन मीडिएशन का जो आउटकम होता है वो नॉन सेटलमेंट में भी हो सकता है. इट्स नॉट मैंडेटरी. एंड ऑल्सो फ्रेंड, देयर इज अ वेरी गुड डिफरेंस. जो आपके बाकी के मीडिएशन होते हैं, डिफरेंट मीडिएशन एंड प्री लिटिगेशन मीडिएशन. प्री लिटिगेशन मीडिएशन में जो मीडिएटर होगा, द मीडिएटर हु टेक्स प्री लिटिगेशन मीडिएशन हैज टू बी एन एम्पैनल्ड मीडिएटर. He cannot be just any mediator or a neutral third party. It has to be a empaneled mediator. Friends, the Mediation Act defines two types of agreement. First is the Mediation Act agreement, and second is mediated settlement agreement. This has been dealt by the previous person, so I will not go into the details of it. But friends, please note, both of these agreements have to be in writing. That is mandatory. Okay, and as we have discussed into the starting, if you read, friends, the Mediation Act 2023 makes an amendment to the Indian Contract Act also. Those who know the Indian Contract Act know section 28 of the Indian Contract Act, where, first of all, exemption was there for the arbitration agreement. If there is an arbitration agreement, it is not considered as an exemption to. So it is not considered as a violation of section 28 of the Indian Contract Act. Similarly, now, friends, if there is a mediation agreement between the parties, it is not considered as a violation of section 28 of the Indian Contract Act. There is a specific explanation that have been made through the Mediation Act 2023. Also, friends, the Mediated Settlement Act agreement also, if it is declared as void under the Indian Contract Act, it has to satisfy the conditions of the Indian Contract Act. It has to be a lawful agreement for a lawful purpose also. So it has to satisfy all those requirements for it to be considered as a lawful settlement agreement. I will just quickly go through the entire mediation process that has been contemplated through the mediation as 2023 is on the screen. This entire process has been explained by ma'am when she was discussing the Mediation Act, how it comes between the parties. Agreement is there. They go to the appointment of the mediator, and from there on, the entire process take place. Friends, there are 2 points that I want to mention here. First one is, what do you mean by commencement of mediation? When does the commencement of mediation take place? And why is that significant? Does it take place from the first appearance before the mediator? And secondly, when does this 120 days time period, जो कि आपको completion of mediation के लिए दिया गया है, when does it commence from? Friends, please note, जो commencement of mediation है, वो किसी एक different disputes के लिए, different type of mediation के लिए, there are different. It is not the same for all mediation. But the 120-day time period, friends, will start from the first appearance before the mediator. It does not start from the commencement of the mediation. Commencement of mediation is different from this 120-day period. Commencement of mediation comes into picture when we are calculating the period of limitation. The period from commencement of mediation to the termination of mediation is excluded while calculating the period of limitation. So please note this, important friends. Friends, some of you have asked also, can the mediation settlement agreement can be challenged before a court? Yes, friends, it can be. Section 28 of the Mediation Act lists out some of the conditions on which the mediation settlement agreement can be challenged. Friends, key features of some of the other key features, as sir has discussed previously, it provides for enforcement mechanism of the mediation agreement as a decree of the court, and as sir was saying, that can be quite a cumbersome way also when it goes for enforcement as a decree of the court. Friends, confidentiality, time limits, roles of the mediation. Confidentiality is the hits at the sanctity of the entire mediation process. It has to be maintained. The confidentiality has to be maintained, and as such, the Mediation Act lays down strict provisions for maintenance of confidentiality also. And friends, interestingly, the Mediation Act also establishes the Mediation Council of India. So far, it has not been established. So once the act comes into force, the Mediation Council will be established also. Benefits of mediation we have dealt with throughout this session, so I'm not going to deal with. Friend, lastly, what are the few challenges before the Mediation Act? First, friends, should we have mandatory pre-litigation mediation? Should we have mandatory pre-litigation mediation? I personally think, friends, we should have. It's a very good step. But yes, some of you might say, look, right to approach the court is a fundamental right. Also, access to justice is a fundamental right. And if you have mandatory pre-litigation mediation, that might hit at the access of justice. But personally, friends, I think it does not hit at that, and pre-litigation mediation can be made a statutory requirement also. This is my personal opinion. You can agree and disagree with that. Friends, some of you have asked during the course of prediction, how do you become a mediator? What are the expertise that are required to become a mediator? What is the training that has to be done for a mediator, friends? So far, the limited relevant experience of mediator is one of the lacunas that we are trying to address also. So more professionally, more mediators who conduct the mediation in a professional way are required. Definitely, it is there, and with a period of time that will happen also. And the Mediation Act lays down some provisions for that. I don't know, when the Mediation Council will come, it will definitely look into that. That is the hope. Friends, but one of the drawbacks of the council, of the Mediation Council, is that before it makes any regulation, before the Mediation Council makes any regulation, it has to take a prior approval of the central government. So, Mediation Council को कोई भी अगर regulation, guideline to conduct mediation or something it has to do, it has to take prior approval of the central government. This might seem like, okay, we don't require the prior approval of the central government, that can be excluded. It might have happen also. Friends, that is another big concern. There are multiple ways to become a mediator. There are multiple multiple platform. You can go to the mediation service provider. You can go to the mediation center. Mediation council will also be there. So one of the criticism of this act is that this can be shortened out. There can be a unified system for for registration for the mediation. And as we have discussed, international mediation still remains to be seen how we will implement that. Friends, with that, I will conclude my presentation, and I thank you all for being here.
Thank you, Vikas, for the concluding words and the concluding insights that you presented to all of us. With this, I thank all our speakers of the day, especially Professor Jose Burgess, Dr. Avinash, and all the other speakers who were there with us, and all the participants who joined us for this workshop. The link of this workshop is available on our YouTube channel. So in case anyone has missed it, you can share it with your friends, and we will also share it with you. With this, I wish everyone a very good evening and see you. Thank you so much.